And we have completed our discussion for today on suits affecting the parent-child relationship and out-of-time appeals in parental rights termination cases. So let's turn to probate court policies prohibiting pro se executors. And for that, Justice Pemberton.
Great, thank you, Chip, and good morning, everyone. I hope everybody's had a chance to look at our report from our subcommittee, which is along with myself, Evan Young, Pam Barron, and Nancy Rister. Small in number, but hopefully helpful in impact. And the accompanying materials we gave you and found them helpful in getting your arms around this issue that the court has charged us with answering. As the court notes, a number of the statutory probate courts have adopted policies that restrict or prohibit independent executors, that is, the people named in a will to administer or settle out an estate, have restricted them from prohibiting without the representation of a lawyer. Incidentally, when we talk about the statutory probate courts, we're talking about a fairly small subset of all the courts in Texas that have some sort of probate jurisdiction, which in the first instance would be the constitutional county judge or a court delegated from there by statute. We're talking about mainly the large urban areas. An example of such a policy we provided you is from the Travis County Probate Court, and it kind of shows you a lot about how the policies work and some of the underlying rationale. We also provided you, we thought it was pretty helpful in framing up both some of the background and also some of the basic legal arguments, competing amicus briefs in the Maupin case. That was an attempt to challenge this Travis County probate court policy brought by a pro se litigant who attempted to proceed in that fashion as the executor of his late wife's estate. On one side, you have the Texas Access to Justice Commission. On the other side, you have the statewide entities representing these probate court judges. Also, the court in giving us this charge referred us to a law review article. It intended that y'all get that before this morning. Didn't work out that way, but it's there. We cite to it several times in our report, and it's there if you want to do some deeper diving either today or later subsequently. We gave you some key cases from the courts of appeals in this area. It appears a big impetus toward the development of these policies was a 2006, and I'll emphasize for the benefit of our colleague, Chief Justice Tom Gray, split decision over his vehement dissent. The Steele case out of Waco, which held that a gentleman attempting to prosecute an appeal could not do so pro se to the extent he was trying to do so in his capacity as independent executor, citing cases both from other states and also Texas cases involving pro se's attempting to represent corporations. The court reasoned that the executor was representing others, not merely acting pro se, and was therefore engaging in the unauthorized practice of law by proceeding in that fashion. Steele has been followed by other courts, including the Corpus Court of Appeals in the Maupin case, and also by the Amarillo Court in Guten Schlow, applying that rationale, that basic rationale to trustees generally. Executors are, of course, in essence, a type of trustee. So against that background, the subcommittee endeavored to answer the question posed by the court: is there a right under Texas law for these executors to proceed pro se? And we understood that to be a discrete question of law. We basically put on our hats as primarily appellate practitioners and our judges and answer yes or no. There are obviously some important and weighty policy considerations that may come into play. On one hand, you have Texas's long history of allowing somewhat distinctly historically independent access to independent administration of estates. If a testator wants to have that done, the idea is to be not involve the courts, be fairly inexpensive, user-friendly. The Access to Justice Commission, among others, perceive that as dovetailing with broader concerns about allowing Texans of all means some reasonably affordable ways to order their legal affairs. On the other side, you have the probate judges. There are concerns about, the potential for, at least when an estate, settling an estate can be somewhat complicated, really making a mess of things both for themselves and others, the beneficiaries affected. And of course, there'd be some burdens on the courts themselves in these proceedings by allowing pro se's. We just tried to answer the legal question posed, not what the law should be, not whether there ought to be safeguards or how you set up forms or anything like that, or whether you should. As best we can tell from where we're sitting, our subcommittee concluded that the answer under current Texas law is yes. And there are three basic reasons for that. First, although colloquially, folks often speak of the quote estate of a deceased like it's an entity, like a corporation. That's not the way it is under Texas law. It just simply refers to the property to which there's some fiduciary duties that arise that the executor owes. Consequently, efforts to analogize the position of an executor relative to an estate to a pro se attempting to represent a corporation ultimately don't hold. The second reason addresses what seems to be the more precise rationale of these probate court policies, at least as articulated both in the Travis County policy and in the brief they filed in Mountain, is that it's twofold. One is that a person who's named as an executor really wears two hats. They've got their individual capacity and their capacity as the executor. No one disputes that. The second part, though, is more problematic. The reasoning is that because the executor in that capacity owes fiduciary duties to others, they are representing others when they attempt to proceed, and therefore an authorized practice of law. And this thinking is very similar to what the law review article by Professor Hatfield identifies as the quote Minnesota rule. It basically holds that an executor is a transparent legal agent of the beneficiaries, and therefore acts only on their behalf, represents them, doesn't act really on their own behalf. We think Texas law, as it currently stands, is to the contrary. A key consideration is the Texas Supreme Court Schaefer case, where the court held that an independent executor sued in that capacity had a right to represent themselves in court and cannot be compelled to hire a lawyer. For this scenario, there could be an argument made that being sued, albeit in their capacity as executor, may be different than the broader issue we're talking about here, but the court sure didn't emphasize. Second, you have the Huey case, where the court distinguished or held that a trustee, the broader class of fiduciaries, a lawyer who represents a trustee is not representing the beneficiaries, but the trustee, the fiduciary himself or herself. And that seems contrary to this Minnesota rule idea that the trustee or an executor, more specifically, would be simply this transparent agent. And third, there's a broader notion that strikes us that we don't normally say that because someone may owe fiduciary duties to a third party, that means that if you proceed in some way, you're representing them in some sense. marital relationships are a fiduciary relationship. Does that mean that married people cannot proceed pro se in Texas court if you're implicated with marital estate? That don't think that's our understanding. And finally, even assuming this notion that fiduciary duties owed equals representing others, in the probate process, the first step is that the executor named in the will has to go probate the will and get appointed and prove letters testamentary. They're not in the role of owing the fiduciary duties until that happens. So it seems like in the very least, they would be able to proceed on their own behalf at that stage. So that is our best conclusion. We hasten to admit none of us have any particular expertise in probate law. We hope we're not missing something, but that seems to be the answer under current Texas law from where we're sitting. And I'd urge that if any of my subcommittee colleagues have anything to add, clarify, correct on anything I've said, please feel free.
Any subcommittee members want to weigh in on this? Okay, they're either slow on the button or they have nothing to say. So we'll open it to discussion. Anybody have any comments about this really excellent memo and presentation? Well, should we call for a vote? Frank Kilstrap. You'll have to unmute. We don't care if we see you or not.
Okay. It seems to me that we may be approaching this problem in the wrong way. As lawyers, we're approaching it as a legal problem. What does the word person under Rule 7 mean? Well, that's for the court to decide. What we've got here strikes me as an administrative problem. The access to justice people say, look, there are a lot of small estates out there that have maybe one asset, and these people shouldn't have to hire a lawyer because they may be poor. For example, I've been taking the last 20 years taking care of my aged mother. She didn't have any money. I don't have any money, but she left me this house and I need to get it in my name. Why should I have to hire a lawyer? The probate judges, on the other hand, say that, well, it's going to be an administrative problem if we have too many pro se litigants out here. And this is not something that's, I think, limited to probate judges. It's limited to any judge in a court with probate jurisdiction. Well, there's not a good solution here via litigation. If you say that the estate is that the person can proceed pro se, then that applies to every estate, even $1 billion estate. I can show up and say, I'm the independent executor, and I want to probate the will. And then if you say that, well, the other solution means that nobody can proceed pro se. This is like the problem that the landlords dealt with a few years ago in justice court. In justice court, we now have a provision in the probate code, the property code, which says that anybody in an eviction can proceed pro se or can be represented by their authorized representative. That's often the property manager, but it also applies to the tenant as well. So what we need here is maybe some type of similar administrative remedy, which the court can give through its rulemaking process. And what we need to do is to take Rule 7 and amend it, which we can suggest the court do. Take the current Rule 7 and make it Rule 7A, and then 7B becomes a rule specifically dealing with probate of a will. And how would you say that? Well, you might start out and say, well, any person can offer a will for probate. And if you go down and get it probated and have letters testamentary issued. Well, that's far too broad. So maybe we limit it to any person who's named as an independent executor in a self-proving will. That makes it much narrower, and it reduces the headaches of the probate judge. But you could also limit it further. One of the suggestions in the materials we've seen is, well, we limit this to persons where they're the sole beneficiary or legatee. I'm not sure what the proper term is. You could do it that way, but there are small estates where maybe more than one person is the legatee. Me and my brother want to own this house. And finally, it seems to me the way that you really could do it would be this, that you could put some type of cap on the valuation of the assets. And I don't know, that there would be some procedural headaches as to how to do it, but we say that a person can offer a will for probate, and if he's named as an independent executor in the will, and he can proceed pro se, provided that the assets appear to be worth less than, say, $15,000. I think something like that would solve the problem administratively. That's all I have.
Thanks, Frank. Richard Orsinger.
Thank you, Chip. So from my perspective, we should not lightly dismiss the role of attorneys in the probate process. And I say that from the perspective of having tried 2 forged will cases. It does happen that people try to commit fraud in the probate process. And right now, if a lawyer is involved, the lawyer has a legal obligation to the society at large not to put forward false evidence and false testimony. And so to the degree that the lawyers are ethical collectively, there is someone who is looking from a close view as to whether the evidence that's being proposed is genuine and whether the testimony is truthful. When you take the lawyer's evaluative role out of a proponent of a will, then you just have the individual's morality or fear of prosecution that govern promulgation of forged or revoked wills. Now, from a procedural standpoint, and I don't do these often, and it's been a while since I did one, but my recollection on an independent administration is that really you have to file an application to probate the will along with the proof of claims, and then you have to go to court and get an order admitting the will to probate, all of which is very perfunctory. And I don't see that there's a lot of procedural complexity there. I don't think there's going to be an overwhelming burden on the trial courts having orders thrust upon them that are inadequate or improperly drafted. So, filing the application for probate, getting the order admitted to probate is fine. Maybe there's some issue here because we have to have some follow through and get the oath taken because without the oath, you can't get your letters testamentary. And then as I understand it, your final duty is to file an inventory appraisement and list of claims under oath. And there's no, that is, you can get that approved if you want to. There's no punishment if you don't, and you don't ever close the estate. In my experience, there's no final approval of anything. So it's up to the executor to give notice to creditors, if there are any, and then to decide which claims are going to be paid voluntarily and which ones are not. And if all claims are paid, then they're supposed to distribute the assets in accordance with the will. But if there's a contest of a claim, the executor has to reject the claim, and then there's going to be a lawsuit over the claim. And that's more in the nature of an adversary proceeding. So I don't have very much discomfort with saying we're just going to let people pro se try to probate a will. I think that does increase the risk that we're going to get improper wills put forward. But if we just live with that risk, I'm okay with that. But when we start getting into complex litigation, when we start getting into a will contest, over competency or over forgery, or when we get into claims involving creditors and the dead man statute and the complexities that go along with probate litigation, I have misgivings about that. And none of that is based on an interpretation of the law as to who is entitled to go in court. I'm just speaking from a practical matter. Probating a will and getting in and out with no controversy, I don't see that there's an important need for a lawyer there. But a complex litigation, including a will contest or including fights with creditors, I do see a problem. But again, none of that is based on law. That's just kind of my perspective of the practical issues. Thank you.
Thanks, Richard. Roger and then Kent. You got to unmute, Roger. Right.
All right, there we go. I really only I had two questions. Is it correct that this is only being proposed for independent executors and not other state representatives? Because and it makes a difference, because if you're an independent executor, that means the deceased went to all the trouble to probably to visit an attorney who drafted a will. I mean, I don't know what's in these, will kits that you get over the internet, but generally speaking, if there's an independent executor, that means there was a will drafted by an attorney somewhere. And the next thing is this problem solvable by a rule? I mean, are there, I will just say, for want of a better term, criminal statutes that can't be overridden by a rule about the unauthorized practice of law? So I guess those are my two questions, whether we're only addressing independent executors, and second, even if we adopt a rule in whatever form, can it still be challenged? That's it.
Thank you. Justice Pemberton, you want to respond to that?
I can respond to the first question, and yeah, it's in one of our footnotes. There is a distinction, at least in some context, between independent executors who, as Roger references, are named in the will, and the idea is you set up the independent administration and do some planning, so it's an easier process for getting it all done. And an independent executor, in the sense of there's not an independent executor appointed under a will, or there's, where the heirs can get together and other means get the court to appoint a different kind of independent administrator to do this similar work, but it's just a different process at the front end. It involves some additional findings by the court of necessity for the administration, a few other hurdles. So we're not, we saw that distinction, and sometimes the terms are used interchangeably. We wanted to make clear we were addressing only executors. That is the question posed by the court.
Okay, great. Thanks, Judge. Kent.
As I understand it, the committee's recommendation creates a default to allowing pro ses, and that's something that I would certainly support. I take Richard's comment, which is a serious one, to be one that maybe there is some subset of this universe that should be recognized as sufficiently complex that would perhaps allow the discretion for the appointment or for the process to effectively insist upon the involvement of a lawyer. And I think that would probably be something worth considering. That is, if you met some requirements of at least a threshold level of assets and some elements of complexity, that there would be the discretion to insist on a lawyer being involved so that it didn't burden the entire process. That said, I think we're always at risk of perhaps zooming by what may be one of the most important elements of this calculus, and that is to revisit the process as a whole, which of course may require revisiting some of the statutory framework as well, to ensure that it is uniformly user friendly. And by that, I mean pro se friendly, if indeed we're going to set up a system that will be disproportionately used by pro se litigants. It needs to be something that, where there is the availability of plain language explanation and instructions for people that otherwise want to access the system. And as several people have commented, I don't have the data, but it would certainly be my assumption that the vast majority of these cases are represented by people with very, very limited assets and very straightforward wills that require disposition of assets. And to the extent that that's what we're looking at, a simplified pro se friendly process, one that has reduced cost, that ought to be what we're shooting for. Thanks.
Thank you, Ken. Justice Christopher and then Roger.
Well, I was briefly reading the amicus brief of the probate judges, because we don't have a probate judge here, do we, to talk on this issue? And one of the things that they cite is the fact that they have an obligation to see that independent administrators meet their legal duties under the Texas Estates Code. And they argue that the way they can see that done is by requiring a lawyer to make sure, and that they are in a unique position of facing personal liability for judicial acts if they fall short through gross neglect in connection with the reasonable diligence standard of the independent administrators. So I can understand why, as a matter of policy, the probate court judges would want to have lawyers instead of people pro se to make sure that the independent administrators meet their legal duties. And I think that that's what they have done through the use of these local rules. So, I don't know whether the committee looked at that aspect of it at all, had any recommendations, whether, that's something that ought to be taken up by the legislature in terms of, what does it mean for the courts to use reasonable diligence to see that independent administrators meet their legal duties. So, I can understand why they passed the rule that they did, given the requirements that they have, which is different than most other judges.
Justice Pemberton.
Quickly, I'm aware of that argument. I took a look at that statute. It refers to, looks like court-ordered administration rather than the independent executor scenario we're talking about here. Admittedly, we've emphasized this all along, we're not probate experts, and there may be a point in the process where you want to have more people around the table on all sides of this who can claim some real expertise. But I think it wasn't clear that provision applied to the situation we're talking about here, the independent administration by an independent executive.
Thank you. We got Roger and then David Jackson and then Richard Orsinger.
Well, I can't believe I was going to even say anything on this, and yet here again I am. Having recently been the independent executor of in a no muss, no fuss probate proceeding, I can tell you that even when there's not going to be any contest, there are just still some technical things to do that even if you're an independent executor, such as filing tax returns and filing inventories with the court, et cetera, and especially in some of the larger counties where you have specialized probate judges who do nothing but eat, sleep, and breathe probate law all day long. I can understand then why they would even want the uncontested issue ones handled by a lawyer. I certainly went to an attorney. That said, this is Texas. Right now, we think pro se is wonderful. So all I can say, my comment was this. Based on my own personal experience, if we increase the number of pro se independent administrations, what we're eventually going to have to start doing is what we did with family law. They're going to start, the judges are going, we're getting crazy orders. People aren't doing their job. They aren't meeting the deadlines to file their inventories, et cetera, et cetera, et cetera. And as a result, they're going to start saying, if you're going to have pro se people and we have to tolerate it, then we're going to want state approved forms. And we're going to have to do for the probate courts on these pro se cases, what we have been pressed to do in the family law area. And maybe that's a good thing, but I'm saying if this is the way we go, that's what may be down the road. We need to think about that. Enough said. That's my 2 cents.
Thank you. Thanks. David Jackson.
Well, unfortunately, I'm exactly in the position we're talking about. We buried my mother last Friday, and I'm the independent executor. I would be terrified to try to do this without a lawyer. I think if you do this, you need to have limits on the amount of the trust or the estate. You need to have limits on the number of beneficiaries. I mean, there are so many things that kick in that, I've been around you guys for 29 years. I've been around lawyers for over 50 years, and this is overwhelming.
Thanks, David. Pam Barron.
I guess I just want to point out 2 things. One is this is not a uniform practice. It's mostly a practice adopted in the specialized probate courts. So if you take your probate matter and you're an independent executor in some county that does not have a specialized probate court, you are likely to be allowed to proceed pro se. So we have disparate treatment of similarly situated litigants depending on what court you're in. And the second thing is complexity is not a factor. You either have a right to self-representation or you don't. I can represent myself in a very complicated business dispute on my own behalf, even though it might involve significant damages, $10 million, whatever. But that's not the criteria that we have generally used in deciding whether you're entitled to self-representation.
Thanks, Pam. Richard, you or somebody had their hand up. Justice Gray, there he is. Justice Gray. You may be muted.
I am now unmuted. I was going to stay out of the fray since I was unable to persuade my colleagues in the opinion that seems to have started this. And Bob, given the length of the opinions that you write, I was very pleased with the very succinct brevity of your excellent opening and presentation of the issue. But this issue reminds me of one of Kinky Friedman's slogans when he was running for governor. And that is that the probate judges should be required to participate in the pro se fund just like the rest of us judges. And so if we as Court of Appeals judges could write an administrative rule that said, hey, nobody gets to appear in the appellate courts pro se. They have to be represented by counsel. It'd make our job a lot easier. It would put the litigants at less risk. But Pamela was right on point about this is not about risk and rewards. This is not about what is good or advisable or anything of that nature. David, I am just express my sympathy for the loss of your mother and the process that you are embarking upon. It is not for the faint at heart. But the one of the things that we have not focused on, nobody's mentioned this, and I'm even hesitant to bring it up. And first, let me do one little preface. I did estate litigation for 3 years when I started in Corsicana with Dawson and Sod. We did a lot of it. There was a firm there that had probably written 10,000 wills, and they would not get involved once there was any dispute among the heirs. And we were one of the firms that they would routinely refer contested estate matters to. And so we handled a lot of them in a lot of different situations. But we're the lawyer. That was fine. I mean, it's, if you ask, 100 probate lawyers whether or not this is a good idea, I suspect you're probably going to have at least 99 that say this is not a good idea. They need to have lawyers. That's the nature of the beast. Same with the judges. They're going to want lawyers involved. There's levels of protection that come with that. But there are really two different types of representation by the executor that is at issue. And it was the second type in the Steele case that is in Bob's work. The Gene Steele was not attempting to represent himself in the capacity to be an executor or of being an executor in a probate matter. It was a piece of litigation that involved the decedent and therefore the decedent's estate. And because he was the executor of that estate, he was attempting to represent the interest of the estate in that litigation. And that is fundamentally different than the perception that I think most of y'all are approaching this with, that we're talking about the person representing themselves in the estate administration pro se. Two different situations, but the same rule should apply. I go back to what Pam said. It is not about whether or not it's a good idea or not, or it's about a right to do it. In Texas, if you went to Baylor, you had a trust and estates from Tom Featherston, former Baker and Botts attorney, that you're talking about somebody that lived and breathed estate administration. He did. He still does. Amazing guy, extraordinarily knowledgeable. And it is his phrase that I included in my dissenting opinion, that an independent executor can do anything that the person could do if they were alive. And that is exactly what I was arguing in the dissenting opinion to the order in Steele, is that the individual, a guy named Bo Duke, if he was alive, he would have been able to represent himself in the litigation that was going on. But Bo had died. There's a whole long story behind that. And I won't get into it here, but it's very East Texas in its nature. I'll just say the footnote to get your interest. After years of being missing in litigation over this 900 acres, his remains were found in the bottom of a well on that property. So if that doesn't pique your interest in going back and read some more, I'll leave it at that. The point is, if Bo had been alive, he would have been able to represent himself in this litigation. Ergo, his independent executor that had been appointed to administer his estate should be able to do it. And Tom Featherston could find no prohibition against such a representation, and I can find no prohibition from such representation. Whether or not it's a good idea, that is an entirely different matrix. Whether or not it can lead to liability on behalf of the beneficiaries of the state, different matrix. That is not what we're evaluating. It may not be wise, but there is no legal prohibition to doing so. I'll leave it with that.
Thank you, Judge. Nina?
Well, I should know better than to follow Justice Gray. I don't have a story about someone at the bottom of a well.
We'll pick it up.
This is so interesting, right? Every time we deal with some type of opening up the system to non-lawyers, we're always struggling with the same issues of the need to provide an easier option or greater access to the courts. And we always worry about all the rights that might get lost. And so I have to say I lean toward opening it up, but I also am sensitive to Justice Christopher's reference to the amicus brief of the probate judges. And I do think it would be valuable to hear from a probate judge on this. And the specific question I would have is, if you were presiding and you saw some miscarriage or some problem going off, or you were concerned for your own responsibility by statute, couldn't the judge in that particular situation go ahead and require counsel? I mean, is that not an option? Do we have to have a rule otherwise? Can't this be on a case-by-case basis?
Justice Pemberton, do you want to address that? Or
Well, there is a provision, and we reference this in the report, giving the probate judge some degree of gatekeeping if on various statutory grounds why the nominated executor, I forget the term that's used, but one of the 6 or 7 categories, in addition to being felons and that sort of thing, is quote unsuitable. Now, what exactly that means or could mean, don't know whether that would come into play or not. And again, we're not experts on probate. The brief look we made in that area, it appears to be when you have an executor who's crossways or has some kind of conflict of interest with some of the beneficiaries. But whether that concept could extend to, the situation you're describing, I just don't know, but conceivably could have that potential. And that's in the probate code, to be clear.
Richard Orsinger.
I would comment 2 comments. One, Nina, one of my concerns about going this route is that the probate judge will not know that there is a problem, most likely. If the executor doesn't file an inventory appraisement of listed claims, the judge will not have any idea whether it's a $100 estate or a $10 million estate. And so I'm not sure that is much of a safeguard. Again, I'm not making a legal argument, I'm making a policy argument, but when the court appoints an individual as independent executor, the court is making them a legally appointed, legally approved fiduciary for other people. And, some wills are simple. There's one child in the house and the car and the money goes to the child. Others are not simple. Sometimes trusts are supposed to be set up. There are other complexities that can occur. And if we allow, if we agree that the policy is that everyone has a right to be unrepresented in the probate, that applies to the big estates as well as the small ones. We won't even really know what the big estates are. And the fact that these people are legal fiduciaries and perhaps will have no legal advice is concerning to me as a practical matter. And I think that we shouldn't just focus on the rights of the executor to go into court, but we should realize that the executor is by law a fiduciary for other people who are not represented and who are not in court. And so when we establish a right of one individual, the designated independent executor, to go forward without attorneys in a trust position, perhaps with no legal guidance, we could be impairing the rights of the beneficiaries. And so I don't think that it's just a clear-cut question that if I'm sued as an individual, I have a constitutional right to represent myself. When you're asking do I have the right to represent myself if I'm a fiduciary for others and none of us are represented? I think the question is a policy question, admittedly, but I think the legal decision should at least consider the policy, if not be driven by the policy, that this is a court-appointed fiduciary whose duty is to act for the benefit of others. Thank you.
Thank you. Frank Gilstrap.
Again, I think it would be a mistake to try to deal with this in terms of legal issues. Maybe there's a right to represent yourself. Maybe there's not. Maybe that right does translate to representing an estate, or maybe it doesn't. If the Supreme Court says it doesn't, it seems to me it's a powerful argument to say that there is no right in that situation. Similarly, with regard to liability, if the Supreme Court passes a rule that says you can proceed pro se, then I don't think the probate judges have got much to worry about in terms of being held liable for permitting the person to proceed in accordance with the rule. That's it.
Okay, thank you. Justice Gray.
And if I focus too much on the terminology of the right of the executor or person in that capacity to act as such, let me make it clear. It is not about his right to do it. One, it's about not being prohibited from doing it under the law, but it is the decedent's right to appoint someone to do that. That's whose rights will be trampled on if we do not allow the independent executor under current probate law to do this. Because if the executor can, the decedent can appoint whoever they want to with certain limitations in the statute, which I was looking for and couldn't readily find because they've codified the whole area now, and it used to be real simple, but I can't find it. The point being, the decedent has to understand, and this is where the lawyer that is writing that will has some real responsibility to explain to the person, to the testator, that you are appointing someone that can do all of this, and you need to be careful about who you, but once done and once confirmed by the probate court, they can do it. That's just the way that, at least at Baylor, we were taught, and I think that's what the statute supports, is that the independent executor can do that. And there is in doing estate administrations, doing estate planning, the flexibility that Texas gives an independent executor is a policy decision that was made in the 1800s. It is vital to the effective and efficient administrations of estates in Texas. Every time that we encroach upon that, it is a burden on thousands and thousands of estates that are opened and administered every year. And we need to keep it, to the extent that we have anything to do with it in this subcommittee with regard to recommendations to the Supreme Court in a rulemaking capacity. If there's going to be changes, let it be the legislature. But right now, it just needs to be clear that independent executors can do this. I'm sorry, I'm a little bit passionate about this among other areas of the law, but this is important because not only is it philosophically sort of, we've talked about a lot of policy today, and policy is not what should be doing here in the judicial branch. That's the legislative branch. But if we're going to talk about why to do some rule, I'm telling you, we are going against over 100 years of legislative history if we circumscribe the authority of an independent executor. I'll try to be quiet.
Thank you, Justice Gray. No need to apologize for your passion. We love your passion. We live for it. Judge Esteves, did you go to Baylor, by the way?
I was going to start off with, as another student of Professor Featherston, I will say that I do wholeheartedly agree with Justice Gray. I think it's totally unwise. I mean, when my husband passed, I hired a lawyer, and I am a lawyer, but I mean, it is unwise to do it. However, the question, as some of us have redirected us to, is not whether or not it's wise or not, it's whether or not there's a right to it. And yes, you do have that right to go forward. I think it's clear. And I think that some of the other policy, let's think of the other policy sides, who's gonna pay for it? So are you saying that if we made this a requirement, and maybe there is a whole bunch of complexity, and maybe I'm the sole heir, why should I give a lawyer $50,000, even if it's complex, of my money that I could have gotten through and done that full, gotten the estate all the way through probate? I don't think it's fair to the beneficiaries. Perhaps there needs to be something that the legislature, and maybe there is a rule somewhere that allows a beneficiary to come forward and require a lawyer when the independent executor is having a position that is contrary to them. I mean, I think usually they'll hire a lawyer and then they start suing on fiduciary duties and things like that. So there's an internal one, I just my 2 cents is just, you have that right. There's always that issue of whether it's wise, and we have that every day in our pro se divorces, and I still struggle with that weekly because it's not always wise. Usually it's not at all. So that's all.
Yeah, thanks, Judge. Judge, you raised a point that the probate judges in their amicus brief raised in the Maupin case, which is, they say the only source of the right to appear pro se is found in Rule 7. Is there any other source of the quote right to represent yourself other than Rule 7, or is it derived from the Constitution? Maybe it's not fair to ask you. Maybe I should ask everybody. But what do you think about that?
You're asking me. We didn't. I'm sorry.
I was asking Judge Esteves, but you'll do.
Well,
I'm sorry, I didn't realize you were asking me.
Yeah.
No, I don't know where it is. I'm not gonna, I studied that in law school and then I didn't go forward with that. So it's been a long time since I've done a lot of probate type of law. But I will say that wherever it is, I mean, it's been clear. I didn't have any question that I could have, and I had beneficiaries that would be, stepchildren against my biological child when I hired a lawyer, but I believe I could have gone forward. It never even dawned on me that I couldn't go forward as an independent executor representing myself, or, going forward in that probate. So I don't think we don't have a probate court here. So we have, it goes into the county judge, but
Right.
There's no question that people can represent themselves, or the estate, the independent executor can do all of that.
Thank you. Justice Pemberton, did you want to answer the question I posed, or no?
Not much further. My sense is the notion of a person being able to represent themselves in part is with reference to the definition of the practice of law or the unauthorized practice of law. And if you're just representing yourself, you're not engaging in the unauthorized practice of law. And there may be a constitutional underpinning, although we didn't try to answer that extensively. The law review article, and Chip, it may have been the footnote you mentioned earlier, actually by 87 does speak to there possibly is an argument for a constitutional right to represent oneself, but we didn't try to answer that.
Thank you. Justice Christopher.
Well, when everyone was talking about the idea that the executor is this can do the same thing that the decedent can do, I was sort of thinking outside the box and thinking, well, perhaps we need to say in the will that an independent executor doesn't need a lawyer. And that way I, as the decedent, know what I want my independent executor to do. Do I want them to hire a lawyer, or have I picked someone that I think is capable of handling my estate without a lawyer? I mean, most wills have independent executors. They also have a provision that says the independent executor can hire a lawyer, and the fees for the lawyer are paid out of the estate. So, it seems to me that if we want to have, if it's a small estate, or if the decedent wants to take the risk that whoever they have listed as the independent executor is capable of doing it without a lawyer, it ought to be in the will.
Okay, Lisa.
That is a philosophically sound proposal, but a practical nightmare. I mean, the amount of wills that currently exist with independent executors, they all need to go get rewritten if they want to self-represent themselves. Like, I feel like I hear what you're saying, Judge Christopher. I just don't. I'm not going to go rewrite my will, even though it does set up an independent executor, and even getting the word out that you would need to, even if you weren't a part of the 50 people on this discussion board. I don't know. I just wanted to remind everybody that we're talking about a ton of wills in Texas that are currently written and that will at one point be administered.
Okay, great, thanks. Justice Pemberton, I will return to my sort of my question, which is, would we, if we decide to follow the subcommittee's recommendation, would we be telling the Supreme Court that it should revise Rule 7 or do something else other than revision to Rule 7?
Well, our charge, as we understood our charge, we were simply answering what is the legal status quo. Is there, and I think Justice Gray stated this better than I probably did, is there a prohibition against a person acting in their capacity as an independent administrator from proceeding pro se? Where you go from here, it isn't clear you'd need any kind of amendment to 7. In my subcommittee colleagues should feel free to chime in as well. There are apparently some probate local rules that have been adopted by the court that may be inconsistent with the conclusion that our subcommittee reached. And, what you do with those, it's kind of up to the court, and also whether others, presumably those courts and others included, perhaps should be part of the conversation, a broader conversation. So I guess to Chip, we're at the disposal of whatever the court would like us to do on this, whichever direction we should go.
Okay. It seems to me that it might be appropriate after I recognize Richard Orsinger, who's got his mechanical blue hand up, is to get a sense of the whole committee, which way we fall, whether it should be pro se or acting pro se would be the unauthorized practice of law. But Richard, why don't you weigh in before we do that?
Chip, what I wanted to say was, I'm just thinking through the process here. If we authorize a litigant, an appointed executor to be pro se in the ensuing probate litigation, that's one thing. But if a proponent to a will proposes the will for probate and there's a contest, then the appointment will not be effective until the contest is resolved. And so I guess we have maybe a slightly different question from the one that Professor Featherston addressed in his lectures to the various classes. And are you entitled to offer the will for probate before you're appointed? And if there's a contest, are you entitled to represent yourself in the contest because you're not appointed yet? And so I think there may be a public policy we have to grapple with besides the testator's intent. I haven't litigated a case like that, and I haven't fully thought through those thoughts, but there may be a reason for us in our discussion or our writing to distinguish those who have been appointed from those who have not yet been appointed. Thanks.
Thanks, Richard. Scott Scully?
Thanks, Chip. I just want to comment that I think we've got to find a way to allow small estates to be handled without the necessity of paying for an attorney. It just eats up the estate funds. And if people are essentially indigent, we've got to have a way that they can get this done without having to pay for a lawyer. I think sometimes as a profession, we forget how much the general public mistrusts our profession. And so this kind of thing just generates more mistrust if the public finds out that lawyers are requiring that lawyers be hired. That just doesn't help very much, I don't think. And the other thing it's going to do, it's just going to drive this kind of thing underground. People are going to resort to self-help to resolve who owns what after somebody dies. And I think we want to encourage them, even if they're pro se, to go to court and do it legally. Thanks.
When you say self-help, what do you have in mind?
Well, I don't know. They just continue to live in the house, or they move into the house, or they hide from the authorities who actually owns the house. I don't know exactly what could happen, but they just don't take care of it. They don't retitle the car. Whatever might happen, that they just decide, okay, well, I'm just going to go do what I need to do and disregard the legal system.
Yeah, I got you. Well, the subcommittee said in its memo that their view is that executors have the right to proceed pro se, both in initiating the proceedings and thereafter in performing their role. So everybody that thinks that's a good idea, raise your hand.
Chip, to be clear, good idea policy, or that's the legal?
Well, yeah, good idea is perhaps the wrong term. What we should recommend to the court, and I'm going to get to the mechanics of how that's effectuated in a minute, but that it's the recommendation of this committee, full committee, that the subcommittee's view that executors have the right to proceed pro se, both in initiating the court proceeding and thereafter in performing that role, that they're in favor of that. So raise your hand if you're in favor of that. All right, everybody that's opposed, raise your hand. Everybody now lower, and everybody opposed, raise your hand.
I'm trying to lower. There we go.
Okay, is everybody lowered that wants to lower and everybody raised that wants to raise? So it's 18-3 in favor of the subcommittee's recommendation that executors have the right to proceed pro se, both in initiating the court proceedings necessary to effectuate their rights under a will and thereafter in performing that role. So that's the vote. And you can lower your hands now. And now I get to the point where Chief and Justice Bland and Jackie and Martha, what else do you want from us? Do you want us to propose a rule? Do you want us to debate whether you should keep your nose out of this, even though this is what we think is the best policy? What's the court's pleasure on this?
Well, I don't really know. And I wouldn't want to speak for them. So maybe we should take what we've learned from this discussion back and discuss it internally and see.
Okay, Justice Bland, you okay following the chief's lead on that?
Always.
Did you hear that?
No, not always, but most of the time.
I was going to say, we'll see no dissent from a hecht opinion.
Sadly, no. No,
Okay,
that's what we'll do, and it's not going to delay anything because we've got deep thoughts coming up, right? So we could get word back before January.
Yeah.
For sure.
Okay, we'll submit this for now. And now, Richard, I want to talk a little bit to you about these divorce forms.
Yes, sir.
Was this on the original agenda? Marty, maybe you can help me on this. Or did it get added this morning?
Oh, no, it's been on for at least a week.
Okay.
Yes, Chip, it was on the original agenda. Yes.
Okay. All right. I know you gave us some stuff this morning though, right, Richard?
Well, we've been here before. So this is more in the nature of an update than an action item, but let me explain and it'll make more sense, okay?
Well, we'll be the judge of that, but go ahead.
Okay. There was as you may recall, some years ago, there was some controversy about the Supreme Court adopting forms for family law practice.
Really?
And, yeah, I remember that just barely. And
we had our one and only lobbyist, our first, in my memory, only lobbyist,
right,
the Supreme Court Advisory Committee.
It was one for the ages, but at any rate, there's been a movement afoot coming, I think, from the grassroots to promulgate forms to allow people to prove up their divorce without having to go in front of the judge and raise their hand and swear to the grounds for the divorce and at least some evidence of what the arrangement is on the kids. And I'm talking about a default divorce or an agreed divorce. Of course, now we don't even have live hearings. It has to be by Zoom anyway. And they put everybody under oath remotely and you prove your case up to the judge on Zoom and what have you. But what's happened is this grassroots movement was to develop a form to allow you to prove up a divorce by default or by agreement, by affidavit or unsworn declaration. And these forms were promulgated by various people. They were passed around, they were commented on. And the family law section of the state bar finally was satisfied with the condition that they were in. And so they informally endorsed them and have included them in the family law practice manual. And these have been distributed to trial court judges around the state. And of course, they violate the hearsay rule. But if there's no objection to the hearsay, then it comes in as substantive evidence. So as a practical matter, there's very little difference between submitting an affidavit to support a divorce decree and getting on a Zoom conference or even going into court. So what's happened is that these forms have taken a life of their own and they're out there and they're spread around and judges who want to can use them. So at this point, the people who were behind the effort are no longer pushing for Supreme Court approval because it's emanating out at the trial court level on an optional basis. So from the committee standpoint or from the Supreme Court standpoint, they need to decide whether they want to stop this or whether they want to endorse it or do nothing. If they do nothing, it'll just disseminate out there and the judges that want to use it will and the judges that don't want to use it won't. If the Supreme Court adopts these rules and includes them in the divorce packet, that means that judges are going to be required to accept these. Even if they don't like the hearsay, even if they don't like an unsworn declaration, they're going to be required to accept them if the Supreme Court endorses them, includes them in the divorce packet. So first question is whether the Supreme Court wants to oppose the dissemination and voluntary use of these forms by judges. And the second one is, does the Supreme Court want to force judges to use them even if they don't want to? And I feel like that's what remains to be decided, because they've been accepted by the practicing lawyers. They're being promulgated informally, and they're being used by judges on a voluntary basis.
And the family law section has a view on forcing judges to use it?
I haven't been able to, since this got put on the agenda, I haven't been able to get the executive committee to correspond with me, so I don't have the answer to that question.
Okay. And what about on the first question, whether I think you said in the last meeting maybe, or maybe informally when we talked, that the family law section likes these forms?
Yes, they basically vetted them and they've approved them, and they put them in the form book that they sell for use and that's available in public libraries. And they're disseminating around. I mean, friendly judges are using them in their court because this speeds things along, and they like it, and they don't mind the fact that this is hearsay. It's sworn to. You know, we have a historical aversion to proof by affidavit in a trial on the merits. But as a practical matter, there isn't really a functional difference between going under oath on a piece of paper in an uncontested divorce or a default divorce and raising your hand on a Zoom. You know, there is a little more live, and it's maybe a little more persuasive that you should tell the truth when a judge is looking at your image on a TV screen, but it's all very abstract. And so I think people are saying, look, as a practical matter, let's not bother to clog the courts with waiting in line or having Zoom conferences of a series of uncontested divorces, just so they can swear to perfunctory information.
Got it. So you think our discussion should focus on two questions. One, whether the Supreme Court should adopt these forms as its own. And then two, if adopted, whether the Supreme Court should require trial courts to use these forms.
I agree, because I don't think that we're going to contribute anything in this discussion today to improve the form itself. I think the form has been vetted by the people that use it every day, and what we just need to decide is whether we want to stop it or force it, or just let it be what it, whoever wants to at the judicial level can use it, and those that don't are free to reject it.
Okay, Judge Estevez. You have to unmute that.
I wanted to add, you know, we started using allowing the testimony by affidavit right when the pandemic shut us down right at the beginning, before we were even really high on the Zoom. But just we have them only uncontested, and they've signed off on the decree. So I want to make it a little clearer that when he's talking about, you know, one side proves up the whole divorce by affidavit, but both the husband and the wife both signed off on the decree. And so there's not, I mean, even though it's hearsay, it's clear that everybody's on the same page. At least somebody's testifying the same as they would have testified in court. So there's not any harm that I think the judges feel would come from these being adopted. So, you know, we're allowing it. We've done plenty of them. And so I think it's a good thing if that's the way they want to present it, and it's clear it's totally uncontested, then I think it's a good, easy, faster way to get people divorced, you know, without having to take up a lot of the court time and a lot of the lawyer time, and also the litigants' time.
Great, thank you. Richard Munzinger.
Do I understand that these forms take the place of a certified copy of the divorce of an original divorce decree?
No, they don't.
Go ahead, Richard.
This is just an offer of proof in order to get the judge to sign the judgment. This doesn't alter the judgment at all.
Well, I got the impression it was to prove up a past divorce. I got a wrong impression.
Right, it's to prove up a current divorce. And as Judge Estevez pointed out, the last line of it is that both spouses have signed the decree.
Thank you.
And we're given a proposed order. So the order comes at the same time. So when we're looking in our electronic file, we see the affidavit in there, and then we see the decree. So, and it has both of their signatures.
Great. Does that answer your question, Richard?
Yes, thank you.
You bet. All right. Richard Orsinger, do you want us to have a vote on whether we recommend that the Supreme Court adopt these forms?
Sure, and I want to correct, I said that it could be used for a default, but the last sentence in the form saying that the other spouse has signed, I think, as Judge Esteves pointed out, it would preclude the use in a default. So that means that a default judgment, meaning it may be agreed, but it's not signed by the other spouse, would have to have conventional proof. Do you agree with that, Judge Esteves? Okay.
Yes,
Yeah,
we haven't.
I think we just have to decide, Chip, whether the Supreme Court wants to do anything, and if they do, what should it be? To stop it or to expand it or mandate it?
Yeah. Justice Gray?
Richard, is there a sentiment from the practitioners that they would rather just not have the Supreme Court blessing or opposition to this, so that it can maintain its flexibility and not be an adopted form, and the form can morph as the law passed by the legislature may change?
Yeah, I see your point, Justice Gray. I don't think that there's any conscious sense that the Supreme Court should not do something. I think that the pressing need was met and people have moved on to the next problem. So at this point, I feel like the family law bar, to the extent that they've expressed their views to me, is indifferent. They don't take a position one way or the other. The problem is solved as far as they're concerned. But I do understand what you're saying, is that once you officially promulgate something, you're stuck with it until you officially change it. And we're at the very front end of this process, and it could well morph. I think that's a valid point, to do nothing, at least for the time being.
Judge Esteves?
I'm fine with doing nothing or just letting the judges that want to do it, do it. I will say that a positive thing that could come from the form, some of the affidavits I've gotten weren't legally affidavits or unsworn declarations, or sworn declarations. So it would be helpful for even some lawyers to know how to draft an affidavit, and definitely any pro se litigants that wanted to use it. So I've sent them back, and just wrote something on it saying, in insufficient affidavit, please submit a legal affidavit. So that would be a positive reason why the Supreme Court may want to look at a overall very skinny type of form to aid both litigants and pro se lawyers and litigants. Pro se.
Thank you, Judge. Lisa?
Richard, have we heard even anecdotally that trial judges don't think that they have the ability to use affidavits in lieu of live testimony?
Not specifically, I can't say, Lisa, but I will say that it's been my experience generally that judges will reject affidavits. We struggled for that for years in Bexar County, where we have an extraordinary number of distant military divorces that are uncontested, but neither party can appear live. And for a long time, the staff attorneys that were helping the pro ses would actually the petitioner would send interrogatories to himself or herself and then answer them. And then we would use those interrogatories to prove up the divorce. I don't know what the current practice is, so I can't say, but it's just historically, we don't use affidavits for final trials.
Yeah, I mean, I guess that would counsel in favor, if there are judges who are hesitant to think that they are able to use an affidavit, then that would counsel in favor of the court approving something. I'm sorry I don't have the form up either, but I would like it, if the court were to approve something, I would like it in the form of a sworn declaration as opposed to an affidavit, or maybe both. Just sometimes getting a notary is a pain, and also not required under the law anymore.
There are actually 3 forms, Lisa, and one of them is an affidavit and 2 of them are unsworn declarations.
Okay.
So
Sworn
that,
declaration.
I'm sorry, one is, but they were unsworn declarations.
Well, a declaration by nature has to be sworn.
It's sworn. It has to be sworn under penalty of perjury.
Well, okay, I won't fight with you about that, but I think that the declaration is not sworn in the, well, anyway, never mind. We can discuss that privately.
Justice Christopher.
I think it might be useful to find out whether judges would allow the affidavits, but my guess is that there are a fairly large number of judges that don't, just because of the opposition we had the last time to doing divorce forms. A lot of that came from the judges in addition to the practitioners. So I would be in favor if the committee thinks it's a good idea to have the Supreme Court bless this.
Justice Kelly, but before you make a comment, Judge, we'll need some illumination on what the picture is of. And you'll have to unmute to tell us.
Nope. I didn't even realize I didn't have my camera on. Actually, that was a mistake. I did not mean to make a comment. That was a typo. But that is the Alhambra, the General Fed Gardens in the Alhambra.
There we go. Very nice. Thank you. Well, that's it in terms of hands up. So let's see about taking a vote. How many people are in favor of the Supreme Court adopting these forms? Raise your hand if you are in favor. All right, everybody lower your hand. And everybody opposed to the Supreme Court adopting these forms, raise your hand. Anybody else? Okay, the vote was 22 in favor and 3 against. So the committee recommends that the Supreme Court adopt these forms. So now you, 3 of you, lower your hands, and let's vote if there's not going to be any discussion on the issue of whether the Supreme Court should require trial courts to use these forms that it adopts. Everybody in favor, raise your hand. Anybody else? All right, lower your hands. And everybody opposed to the Supreme Court requiring trial courts to use these forms, raise your hand. Anybody else want to vote? Everybody finished? Well, in a razor thin vote, there were 12 in favor and 13 against. There'll be a recount in the morning, but that's our thought for the Supreme Court on that issue. You can lower your hands unless you want to speak. And Marcy, do you want to say something?
Sorry, no, I was trying to lower it.
Okay, great. Richard, anything else, Richard Orsinger, anything else you want to talk about on these forms?
No, I think that's it, Chip. If the Supreme Court wants us to do more, just tell us what to do and we'll do it.
Okay, great. Well, that completes our agenda, everybody, in record time as far as I know. So let me just make a couple of brief comments about our next meeting, our Deep Thoughts meeting. One thing I think we should discuss, and frankly, I'd like to see it discussed in some detail because I have a personal interest in this, and that is the issue of judicial selection. By the time of our next meeting, which will be, Marty, December
4th. December 4th.
December 4th.
Yes.
So by the time of our next meeting, the Commission on Judicial Selection will have only one more meeting before it has its final report to the legislature and to the governor. And we might send a copy to the Supreme Court and the Court of Criminal Appeals. Of course we will. But it'd be great to get this committee's views on that. My plan is to have somebody from the commission present to us the thinking at the time on December 4th about where we're headed and some of the ideas we've heard about. We've had committee meetings every month except for March and April. We did not have a meeting for pandemic reasons. We've had 3 public meetings around the state, one in Corpus, one in San Antonio, and one in Midland, Odessa. I don't know if we're going to have any more public hearings or not. We've collected an enormous amount of information, and we're getting additional information as well. So we've heard from a lot of people, but we haven't sat down and talked collectively about what our collective views are on what should be done, if anything. So I'd like everybody to think about it, and I'd propose devoting as much time as necessary to that issue. So that's number one. Number two, if anybody thinks that we could profitably hear from somebody on another topic other than judicial selection, please let me know and I'll try to arrange to have that person present. I'm also going to try to arrange to see if some members of the legislature will attend our meeting and provide whatever thoughts they have. And what the chief said at the outset is really true, at least in my experience, and that is that our 3 branches of government work together very well, and the state is much better off for that. That has not always been the case in our state, but it certainly has been in the last couple of decades. And frankly, this committee has played a role in that, maybe not a huge role, but certainly a role, because I think the legislature has confidence in this committee that we will try to give our best advice to the court, and that we'll do so fairly and honestly and thoughtfully. And I certainly appreciate everything that you all are doing, all the hard work and the hours that you put into this project. And I think we're making our state a better place because of it. So there's a pat on the back for all of us, if nobody else wants to pat us on the back. So unless there's anything else, we will stand in recess. And thanks everybody for everything.
Can I say something?
Yeah, certainly, Roger. Or whoever.
This is Eduardo Rodriguez.
Eduardo, sorry, Roger was raising his hand.
Your comments about about our three branches of government working well together. I would like, because of my being involved with the access to justice and going to Washington to lobby for that, I would like to let you all know that a lot of the reason why they are working together is due to our Chief Justice and the work that he has done in regard to making sure that we have adequate funding for access to justice on the state level and on the national level. And so I think a lot of the good that we're benefiting from is due to the hard work of the chief. And I just think that you all should know, because you may not know of the difficulties he's had when we go to Washington and talking to some of our congressmen to fund legal services. But those of us that have gone there with him know that he's sat down with some of the most conservative congressmen we have and has changed their minds about that. So I'd just like you all to know that.
Yeah. And the great thing about Zoom is we can see the chief blushing there.
No. Thanks, Eduardo.
Anything else, Nathan, that you'd like to say?
No, thank you.
Yeah. Yeah. Don't tear up on us now.
Right.
Anybody else before we recess? All right. Well, thank you all, everybody, for coming, and